What you know, Alibis? Welcome to another episode of Pretty Lies and Alibis. I'm Gigi. It's Thursday, August 7th. Hope you guys are having a good day so far. I took yesterday off to work in the merch store. I'm still designing a lot of new stuff for the store, but there is some new merch up, so go check it out. And it's 10% off with code Sherlock10. That takes care of your shipping and a little bit of the cost. So I appreciate you guys who have purchased some merch from the store. It helps me keep doing what I love. So tomorrow, Donna Adelson has her final pre-trial conference. I will be live streaming that on the channel tomorrow, so come watch with the Alibis. And I really think this is going to be a very different trial than Charlie's. I mean, we had this new investigation. There is discovery unique to Donna. And they got a search warrant for Charlie's laptop to try and corroborate information they found. And one new big witness that will be testifying is her son, Rob. Her trial begins August 19th. I will be live streaming every day, and at the end of the day, doing a recap in an hour or less of the day's best testimony. I posted a few days ago that Surviving the Survivor podcast, Tim Jansen said he had heard from a source that Donna was offered a deal to walk out of jail if she gave up Wendy. Now, there have been some statements since that was said. The defense said that there was no firm offer presented to Donna, and the state said there was no offer. Now, back in July, her defense team was granted a motion by Judge Everett for the state to turn over all of the raw, unredacted emails and cell phone records, as well as telephone conversation and text messages. This is part of that new investigation. Her defense team said the reason they wanted that was to verify state reports generated from Celebrite, which is the extraction software, when they're downloading all of the data from someone's phone. Judge Everett did warn the defense about any materials that might pertain to Donna's previous lawyer, Dan Rashbaum, or her son, Charlie, which he worries could reignite the conflict of interest, which derailed the original trial date. Now, her attorney said he has not discussed that with Donna because he doesn't think that will be an issue. The judge did tell the defense, as far as giving conflict-free representation to Donna, should anything change with your review of the Celebrites that may include communications from prior counsel or deal with matters that pertain to information that was provided by Charlie Adelson, at that point, we are going to have to revisit the issue. At her last hearing, when asked about outstanding motions they intended to file, since that trial date is set to begin August 19th with jury selection, he said the deadlines he set were not arbitrary. The defense said they were not trying to delay the trial, but they have not received all of the discovery from the state. Her attorney said he had 3 additional motions he intended to file. Judge Everett said the proposed date of when this would occur is not specific. It's not certain. It's pretty much a moving piece of jello. Prosecutor Kappelman said both sides were working diligently to meet the deadlines, but pointed out she had matters that are still pending past deadlines, including a report from a handwriting expert. She told Judge Everett, "I understand your comment about the jello. I've got a couple of orders myself of jello that I'm wrangling." And the judge gave both sides a deadline of July 21st to have all that in. So on July 21st, the defense filed a motion in limine regarding travel as a consciousness of guilt. Now, we know she was arrested at the Miami International Airport shortly before boarding her one-way flight to Vietnam. She booked things through third parties, talked about self-harm on the hot mic call. She mentioned she was getting things in order for her grandkids, such as getting trust funds set up. She talked about fleeing to a non-extradition country, purchased that one-way ticket. And also, if you guys remember, there was the mention of a call with her former attorney, Rashbaum, where they talked about what they were thinking up there, meaning in Tallahassee and the prosecutors, as far as arresting Donna. This is not verbatim, but he also told Donna as far as going to the airport and making that flight, she may make it out, she may not. Also, on Monday, November 13th, 2023, a friend of Charlie's contacted the state attorney's office in Tallahassee. They advised Donna and Harvey had contacted them on November 12th, 2023, regarding travel to the Philippines. The Adelsons advised they had travel plans to Saigon until November 20th, 2023, but had no further plans at that time. The Adelsons were seeking advice for airlines as well as places to stay. This family friend has known the Adelsons for over 10 years and has never had a conversation longer than 5 minutes with Donna or Harvey, so they found the contact very strange. Harvey Adelson told the person, "You must not mention to Charlie anything about our plans." So a lot of things going in there. The reason the defense doesn't want this to come in is because it looks really bad for Donna. But the defense said in their filing, new facts and facts known, but not previously argued, warrant the court revisiting this ruling. Specifically, during Jason Newland's July 9th, 2025 deposition, Newland admitted that prior to the warrant for arrest being issued for Donna, she was free to travel and leave the country. Namely, at that time, Donna purchased her ticket to Dubai and Vietnam on November 7th, 2023, then traveled to the airport on November 13th, 2023. She was unaware a warrant had been issued for her arrest, and nothing prevented her from traveling. Additionally, Scott Radius testified at his August 21st, 2024 deposition that Newland told him there is no bench warrant for the arrest, so they could leave the country if they want. Finally, Donna's then attorney, Dan Rashbaum, advised her after Charlie's conviction that there was no warrant for her arrest and she could travel. The attorney also advised she had an agreement with the state that if a warrant were issued for Donna, that Donna would self-surrender at the Leon County Detention Center. Based on these additional facts and concluding the analysis required by both case law and Florida law, the defense requests this court revisit its August 30th, 2024 ruling and prohibit the state from arguing her travel was a consciousness of guilt. My 2 cents, which doesn't matter in the grand scheme of things, is it's coming in. Moving on to the defendant's motion in limine regarding this new investigation. This document is heavily redacted, but let's pick out what we can. On April 7th, 2025, the state disclosed the existence of a new investigation that began after a jailhouse informant contacted the state in December 2024. The first informant's information led to a second informant. Although both informants made statements which were consistent on a limited basis, the vast majority of the first informant's claims were either established to be false or could not be corroborated. By this motion, the defense moves to exclude evidence from the new investigation. One of the informants was interviewed on December 20th, 2024, January 13th of this year, January 29th, and February 11th. Everything is redacted as far as what was said, but underneath it says the new investigation failed to uncover any evidence to corroborate this claim, and there's over a dozen examples that are all redacted on this filing. One example where the wording was different, it said these alleged ties could not be verified by law enforcement. On April 2nd, 2025, Patricia Bird was interviewed by law enforcement. During this interview, Bird made numerous claims about Donna. There's a lot of redactions. Bird confirmed telling the investigators that Katie Magbanawa was arrogant and manipulative, and that Katie got special benefits from guards. She also said Katie told her whole pod that her boyfriend paid for her boob job. However, the original investigation failed to produce any evidence to corroborate that. There are redactions here, but it goes on to say, but suggested Katie paid for the boob job at least in part from the money she received on July 18th, 2014. It is the undersigned's position that these claims made by Bernhardt and Bird are false. It is axiomatic that no party is permitted to present false or perjured evidence. Aside from innocent details, there is no evidence that corroborates their claims. The undersigned concedes that, generally speaking, such evidence is admissible. However, the evidence must still be A, truthful, and B, its probative value not be substantially outweighed by the danger of unfair prejudice, confusion of issues, or misleading the jury. It is the undersigned's position that the claims made by Bernhardt and Bird are false. Additionally, the defense objects to Bernhardt testifying absent an opportunity to have her sit for a deposition. The state waited to disclose the new investigation until about 5 weeks after they last had contact with Bernhardt and 3 weeks after a warrant was issued for Bernhardt's arrest for violating probation, as well as an order to show cause. The next section, evidence is not inextricably intertwined. The Honorable Milton Hirsch stated that a common law inextricably intertwined evidence is defined as other crimes evidence, which must be indivisible from the evidence of the charged crimes, such that the tale of the charged offenses could not be told without relating the evidence of the uncharged offenses. As recognized in McGee v. State, evidence of uncharged crimes which are inseparable from the crimes charged or evidence which is inextricably intertwined with the crime charged is not Williams rule evidence. It is admissible under law because it is a relevant, inseparable part of the act which is in issue. It is necessary to admit the evidence to adequately describe the deed. The Florida Supreme Court has described the admission of collateral crime evidence as inextricably intertwined in the following manner. Occasionally, when proving the elements of a crime, it becomes necessary to admit evidence of other bad conduct to adequately describe the offense or connect the elements of the offense because the charged offense and the other conduct are significantly linked in time and circumstance. In other words, this evidence is admissible because it's a relevant, interwoven part of the conduct that is at issue. When it is impossible to give a complete or intelligent account of the criminal episode without reference to other uncharged crimes or bad conduct, such evidence may be used to cast light on the primary crime or elements of the crime at issue. However, when there is a clear break between the prior conduct and the charged conduct, or it is not necessary to describe the charged conduct by describing the prior conduct, evidence of the prior conduct is not admissible on this theory. Such evidence of other bad conduct on the part of the defendant is admissible where its presentation is part of the general context in which the criminal action occurred. They cite a case, Hall v. State, that says, holding that testimony regarding first-degree murder, defendant's theft of the murder weapon was inextricably intertwined and was necessary to establish the entire context out of which the crime arose. Collateral crimes evidence is inextricably intertwined if the evidence is necessary to 1. Adequately describe the deed, 2. Provide an intelligent account of the crimes charged, 3. Establish the entire context out of which the charged crime arose, or 4. Adequately describe the events leading up to the charged crimes. Moving on in the doc past all the redactions a bit, it says, care must be taken to assure that prior crimes are not received in evidence solely because they precede or closely follow the crime charged. The purpose of this use of such evidence is to complete a picture, not to paint another, and to provide context and meaning to the central events in issue. Other offenses not useful to such ends should be excluded, no matter how close in time or place. Moreover, its admission is unnecessary to establish a material element of the crimes for which Donna is under indictment. As a result, admission of such evidence as inextricably intertwined would be improper and should be excluded on that basis as well. The undersigned concedes, there is a part here redacted, the remainder of Bird's testimony is likely admissible. The same is not true concerning the varied claims made by Bernhardt during her multiple interviews with law enforcement. If she is located for trial and only for those claims which are relevant, the probative value of almost all of her claims is substantially outweighed by their prejudicial effect. In the end, it requests the judge enter an order prohibiting the state from introducing evidence from the new investigation or limiting admission of the new investigation as set forth above. Very, very interesting filing. So, what did these jailhouse informants say? It's all redacted, so we don't know, but clearly they are saying Donna fessed up to something else. So we will see what the judge rules tomorrow about what could come in. This could really spice up this trial in a big, big way. Of course, the defense is like, we don't want that in, y'all. Another motion is asking the judge to prohibit Newland and Sanford from offering their opinions concerning the new investigation during Donna's trial. It says on July 9th, 2025, investigator Jason Newland was deposed. On July 16th, 2025, Special Agent Patrick Sanford was deposed. During their respective depositions, both Newland and Sanford expressed their opinions on the new investigation. By this motion, Donna moves to exclude opinion testimony of both Newland and Sanford. The threshold question for admission of evidence is relevance. In Florida statutes, it permits lay witnesses to offer opinion testimony in limited situations. Namely, it provides that if a witness is not testifying as an expert, the witness's testimony about what he or she perceived may be in the form of inference and opinion when, number one, the witness cannot readily and with equal accuracy and adequacy communicate what he or she has perceived to the trier of fact without testifying in terms of inferences and opinion when one, not mislead the trier of fact to the prejudice of the objecting party, and two, the opinions and inferences do not require a special knowledge, skill, expertise, or training. However, under this exception, opinion testimony is usually limited to matters relating to distance, time, size, weight, form, and identity, which are easily observable. The opinions expressed by Newland and Sanford do not concern distance, time, size, weight, form, or identity. Rather, they concern the truthfulness of allegations raised during the new investigation. Allegations, the vast majority of which are not corroborated by any evidence. Even if their opinions concerning the new investigation were admissible as lay opinions, such testimony should be prohibited as its probative value is substantially outweighed by the danger of unfair prejudice under Florida law. So they're asking for an order prohibiting Newland and Sanford from offering opinions on the new investigation during her trial. And they request that the Honorable Court exclude any testimony interpreting the contents of emails, recorded phone calls, and or text messages, and in support thereof, states as follows. Throughout the prior trials, state witnesses have testified concerning their interpretation of 1. Donna's emails, 2. Statements made by various parties on recordings, and 3. Text messages. They cite a case, Thorpe versus State, which says, during trial, the witness was asked to opine what the defendant meant when the defendant made a statement. The defense objected, arguing that the question called for the witness to speculate that his interpretation was irrelevant and the witness was not qualified to offer his opinion. The trial court permitted the testimony. On appeal, the Florida Supreme Court held, as a general rule, lay witnesses may not testify in the form of opinions or inferences. It is the function of the jury to draw those. Since the witness was able to convey what the defendant said, the exact meaning of Thorpe's words and the inferences that may have been drawn from Thorpe's statement should have been made by the jury and not by the witness. Although it would be appropriate under the rules of evidence for a qualified witness to interpret coded conversations, testimony which interprets clear conversations does not aid the jury and is inadmissible. Even if their testimony were admissible about the meaning of the words, such testimony should be prohibited as its probative value is substantially outweighed by the danger of unfair prejudice. There was a sealed motion in limine by Donna filed on July 29th, and the state's response to that was due August 5th. We do not know what that was about. A couple of other things I don't think have been ruled on, but I would assume would be addressed tomorrow. Is the defense able to identify Rivera as a member of the Latin Kings and still that change of venue issue? So we will see what happens tomorrow. Again, I will live stream that on my channel. I'll post a link on my socials and you'll see it here on YouTube. So come watch with the Alibiers tomorrow evening. I will wrap up that hearing if you're not able to watch, so you don't miss a minute. But seems like the defense is worried about a lot of things, which tells me doesn't look good for Donna, any of this stuff. So that is it for today. I hope you guys have a good rest of your evening, and we will see you soon.